That is dealt with by the definition of due diligence, which requires you to take reasonable steps. Not perfection. If your reasonable steps, if you have made the recommendation, fully supported, and you're knocked back, then you can't be liable. Unless you say, sorry, it cannot be done safely without this. We will remove ourselves from that activity. You can do that. Frankly, you may well question whether you want to remain. But we understand resourcing issues in the sector, and it depends on balancing and weighing it all up. But the bottom line is you have to take reasonable steps to look after safety in the ways that we've defined it, and we'll look at that shortly.
Barry, can I just say on that, because I suspect the question comes from a place which says, I'm in the gun if I'm an officer and I'm putting something up to a board and the board's knocking it back, and what will that nasty regulator do to me in those circumstances? I think I'm on pretty solid ground in saying we're hardly going to be trying to breach the person who's doing everything short of paying for it themselves, in lieu of actually looking at the board members and indeed the organisation which refused on appropriate advice to actually undertake appropriate health and safety activity. If that's the concern, then let me allay that fear right now. As a regulator, as an enforcement agency, we have a discretion, as indeed the police do, as indeed, for example, the police do, in terms of who we prosecute and in what circumstances. And if you're coming to us with that sort of evidence, I think that would be an invitation to our investigators to go and look elsewhere and chase another rabbit down a hole. Well, they're working it, yeah. And
but they're not,
whether
but they're
they're
not being paid. They're
yes, but they're a worker within the meaning of the Act.
Okay.
And insofar as they are performing work.
Okay.
But I mean, you're entitled, look, I appreciate particularly, no, and you should ask, these are the sort of questions we want because they're specific to your sector. You're entitled to ask the question, and the only answer I can give is to the extent that they are now deemed to be a worker for the purpose of the Act and are undertaking work, that therefore they are within a workplace environment, and that an inspector on reasonable notice may seek to enter the workplace if they reasonably suspect it to be a workplace. Barry, you wanted to add something there?
Yeah, can I just simply add that yes, they are a worker, they will have a duty to take reasonable care, but that is determined by who they are, what they know, what their circumstances are, and what's reasonable to expect of them in the circumstances. And the likelihood of them really knowing relevant things is probably fairly limited. The fact that it becomes a workplace doesn't capture them because they are not conducting a business or undertaking. The obligation of a person with management or control of a workplace is specifically a PCBU with control or management of a workplace. So they won't have an obligation in relation to that. It's only a PCBU that controls the workplace. So their obligation is fairly limited, and it's really about common sense.
Thank you. Okay.
If only we could do it. Yeah, I fully appreciate that. What that requires, and we don't have time today, is to really unbundle and look through that concept of reasonably practicable for the organisation. That's the first thing, what the organisation must do, and ultimately withdrawal of services may be necessary if you are unable, for money reasons or any other reason, to adequately and appropriately minimise the risk. And it's about risk minimisation. It's about applying the hierarchy of controls, elimination engineering, people controls and so on. So that of itself is a complex issue. From the officer's perspective, you need to understand all these things and take reasonable steps to see that things are put in place to look after it. So again, there is that balance of reasonableness. It is clearly a tension in the sector. Clearly funding, whether it be government funding, whether it be through bequests, trusts or whatever, you only have limited funds and you have to make do with what you can make do. But it's not simply a case of saying, okay, we can resolve that risk by applying this amount of money to do this, we can't afford it, we'll just have to keep going. There are so many different ways that you may be able to minimise that risk through modifying systems, increasing training, increasing supervision, things that don't require that money.
I think we start from the first proposition that we wouldn't want to put, it's not about a trade-off between client services, and can never be a trade-off between client services and the rights of workers under the Act. But secondly of all, and in the real world in which I know that we all live in this room, you're the second person within my hearing at least today, and the other one was over morning tea, who raised the issue of DHS's funding for back-of-house arrangements and the concerns about, I think we were talking in the context of providing 2 people to execute a lift in a residence but only getting funding for 1, and how do we actually... and that's when I pulled in one of the project officers, Crystal Sheriff, who actually is more knowledgeable about your sector than I, and I can tell you that I can at least give you a minimal level of comfort today and say that we're aware of that issue in the context of funding, placing a certain amount, essentially putting the hands around the neck of your ability to deliver services whilst working safely. We are engaging with DHS on these issues, and if we're not immediately, we will be shortly. And that's as much as I can say right at the moment. I don't want you to think, though, that it's, having walked away from this today, we're just sort of leaving it alone and saying, oh, thank God those questions are over. We're mindful of the concerns from the sector around this and its relationship with DHS in particular. We will engage with DHS to address these issues because we are committed, obviously, as a regulator whose charter is to enforce the Act and regulate to it, to ensure that duties are adhered to so far as is reasonably practicable.